How to patent an idea or product in 8 steps, coming up now. Hi, I'm Oliver, startup coach at AskMeStartUp.com, and welcome back to the channel. If you're new here, please consider subscribing and pushing that notification bell, because otherwise YouTube will not let you know when we publish new videos. I personally have been fortunate enough to be able to file 3 patents during my professional career until today, and I want to share my know-how gained during that process with you so you have a better understanding how the process actually really works. As a short disclaimer, of course, this is going to be focused on the European part, which I know the best. However, this is equivalent to everywhere around the world. The general process will be the same. Furthermore, you will find all the details in the links down in the description. You have that wonderful invention that you've done, or even better, innovation. If you're not quite sure about the differences of the two, there's the video I'm going to link up here. And you're thinking about, how am I able to protect it the best? Very often, a patent pops into your mind. I'm going to patent this. But before you do so, you would have to think of, is it worthwhile to patent it or not? And what are the associated costs? This is actually a topic of a different video I'm going to make down the future. If you like it, please leave a comment down below. So before we start, you have to understand what a patent actually is. So you have that invention that can be a process, a product, an apparatus, something that is new and has not yet been published. However, in order to be patentable, it must be industrially applicable and, very important, have an inventive step. And that inventive step actually needs to be in such a way that it is not likely or easily known by a trained expert in the field to come up with such an idea. Patents are valid in individual countries for specified periods. They're typically granted by a national patent office or a regional patent office like the European Patent Office. And now this is important. Patents confer the right to prevent third parties from making, using, or selling the invention without the owner's consent. And that is the whole trick about it. You want to have full control of who is actually using your own intellectual property. Patents should not be confused with other forms of intellectual property protection, such as utility models, copyright protection, trademarks, or designs. As a summary, a patent is the right to exclude others from using your own idea or product or service or apparatus. So the first thing you want to do is you think about the application of the patent. So the first thing in that part you want to do is do a proper research. You can use Google Patents to start off, but then I would also use the AskMeStartUp website to start off researching keyword phrases that you think are relevant and see what is already in there. If it is a scientific invention, you would also want to check sources like PubMed, for instance, everywhere where you can find public information about something that is similar or not to your product. You want to note those documents down and understand those differences or the similarity of those documents to your own invention or not. Once you've done that, you want to go to a patent attorney or lawyer, and I strongly recommend you doing so, because writing a patent and filling all the applications is a very tricky thing to do, and the language is so unique that no normal human being at the beginning is able to write a proper patent. Hence, you want a professional out there who helps you, who guides you, who also does the verification steps with you. The patent application itself should contain the following things: a request for grant, a description of the invention, claims, drawings, if necessary or if there are any, and an abstract. Usually, an application is sent to the National Patent Office, and they provide you with what is called a priority date, which is the time or date that you have submitted your patent application to the National Patent Office. Priority date actually is the key. Once somebody else comes up with a similar thing, you can already say, I've done this prior to you, or I have been in the process while it was not able or was not possible to be aware that you are working on the same thing as I was. This document will then be taken by the patent office and just verified that the formalities have been met. Language is also an important factor. In Europe, for instance, the official languages are German, French, and English. However, you can file a patent in any language that you like, but are required to come up with a translation once becoming nationalized. First step in the European patent granting process is the examination of the filling. This involves checking whether all necessary information and documentation has been provided so that the application can be accorded a filling date. The following are required. Introduction to European patent is sought, particulars identifying the applicant, a description of the invention, or a reference to a previously filled application. Now, if you're very urgent and you think like somebody else might be coming up with a similar patent, you can already fill the patent in there and get this submission date, and then have 2 months time to fill the claims, which actually specify what patent is specifically about and how it differs from others. So you have handed in your patent application with the patent office. They say that the formalities have been met, and now they start immediately up with a search. Usually that still can take, like, say, up to 6 months from personal experience, because they are swarmed and filled with patents up to the roof. And once this patent officer has been checking your application, he will come up with an objection with documents that he found and he thinks are relevant to your personal application. You will need to answer the questions and the objections that they have. You have to counter them with arguments, or maybe adjust the patent applications in such a way that you either exclude certain claims, or you kind of minimalize or put stronger boundaries to them so that they don't appear to a much broader application type. Why is that relevant? Usually you start filling a patent with the broadest possible application and usage profile possible. What that actually means is you want to have the largest coverage you can possibly think of, even outside your current industry. If they don't accept it, bad luck. If they do, wow, you got the jackpot. You can prevent a lot of things. With the examination process by the patent office, also, and unfortunately that happens, fees are due. And please pay the fees on time, because if you do not pay them on time once, you might drop out of the complete process forever and your patent is gone, and you might start to refile the patent, but of course with a later date of priority, which might not be your preferred outcome. Hence, remember, pay the fees to any patent office, always on time. So 18 months are over and your application actually becomes public. So now everybody can see that you have been filing a patent on a specific topic, and now people can look into what you have been filing for. They might come up with objections. Company might attack you on this and say, no, that's not possible. Or they might ask for further clarification. However, it's your turn now to decide what you want to do. And usually when you hand it into a national patent office, you could go, in the European case, for instance, to the European Patent Office. And the next step would be fill in a PCT form, which is the Patent Cooperation Treaty. This actually gives you access to international patent offices, and it will be spread according to your choices to the national patent office. From the date of publication, the patent provides a provisional protection of your patent filling until proven otherwise. After the 18 months, applicants then have 6 months to decide whether or not to pursue their application by requesting substantive examination. The substantive examination actually is the part where the patent officer really deep dives into your application and tries to figure out if it is in accordance with European law and in accordance with all the other patents that are around your invention. He wants really to make sure that you are not infringing other patents, or that your invention is really new and has this novelty character. This can take a long time, and it is unclear how long it actually takes. It can take, let's say, 1 year. It can take 1.5 years. That actually depends on the workload of the patent officer. This is also different from country to country. Meanwhile, you fill the PCT application in, let's say, US and Japan and China, wherever, and they also start to investigate themselves after they have gotten the translations in their national languages. And always remember to pay the fees. Now, after the substantive examination, actually the patent officer comes back to you with a statement whether your patent is able to be granted or not. After you paid the fees and the decision has been taken to publish your patent, it is the publication date that is actually granting you the patent from that day on. From that day on, you will have 25 years minus your priority year to cover or protect everything according to this patent, if you keep paying the fees. Now, as you can see, this is quite a lengthy process, and everything in there is sometimes unpredictable. I can tell you that I have had, with all the 3 patents, a lot of back and forth with the patent lawyer, then a back and forth with the patent officer, can be twice, can be 3 times, can be a lot more. However, most of the times you have to come up with something that is very unique, and they want to understand what is unique about it. And that's my pro tip number 1 here for today. If you want to see whether a patent is different for your own invention, you go to the first claim and then go to the lowest paragraph. Usually the last sentences describe the difference of this specific application to all the others or to your own. This is then where you can understand what is it that they're really patenting in there, because today the world of patents is so huge and vast that it is really detailed information you put out there so that you are able to protect something, but it is because of that detailed mechanisms that you then have to understand what is it that you have to prevent to do and what is it that you actually can or are allowed to patent. From my personal experience, I can also say that the different national patent offices usually find the same things that are likely or not likely to disturb your patent. However, there seems to be a difference between the interpretation of data and facts between the US and Europe and the rest of the world. And that very often is that American patent offices are more likely to grant a patent for a claimed novelty of an invention than Europeans, which are much stricter. The same is true for China and Japan. This actually comes sometimes up to the fact that people are having a US granted patent and still waiting for European ones, or you cannot actually fill it in Europe. And that's also tip number 2. Never ever talk to somebody else about your patent application prior you talking to your patent lawyer, because if somebody knows prior you filling in and submitting your patent application, this might be considered novelty destroying, and then it might not be granted. And all the work and payments that you've done, gone for nothing, right? So keep that in mind. Third pro tip, I already mentioned get a patent attorney, but this is also very important because they will have to keep track of all the dates and payments and fees and all the other things that are in this world out there that you don't want to miss. You don't want to track everything automatically because you might lose the stuff. But they are so professional, and I can tell from my personal experience, our patent office, patent lawyers or patent attorneys, they have been taking care of everything that is concerning the legal side and the technical application side, so that we would not have to worry of, missing a payment or missing a deadline or anything like that. And finally, one small comment here. Reading patents can sometimes cause headache. Really? Yes. It is a language sometimes really hard to understand. And to be honest, I have had to read my own patent twice to understand what I just patented or applied for patent. Crazy. So what are your questions concerning the patent application process? Just leave a comment down below and see you next time.